You think you know who did it?
Join us while we take an irreverent look at your favorite TV crime drama on These Are Their Stories.
But you don't know who did it.
Each podcast will look at an episode of SVU, Criminal Intent, or Original Recipe, then talk about the ripped from the headlines case that inspired the show.
My one disappointment with this episode was that there wasn't a good iced tea looks like.
What do you mean by that?
Well, a good SVU is like, looks like the captain went down with the ship.
One of the pleasures of Criminal Intent is that the perp will not be spared a point-by-point explication of how Gorin figured it out.
I like Barba.
He certainly seems like the most put upon.
Oh, wait, you want me to prosecute this?
I know, like he can't believe it.
How many damn rapes are there in this city? Yeah, exactly.
John Cryer, you know better than most that a major cast change can sink a successful series if not handled right.
Yes, you gotta say trigger warning.
Yeah, trigger warning, sorry.
Goes to the predictability of this character that he was on trial for rape that day.
So there was a scene where Briscoe was talking about how his father was in World War II. And all I'm thinking is, your father was in World War II? I thought you were in World War II. Subscribe now to These Are Their Stories, the Law & Order podcast, at iTunes or wherever you get your favorite podcasts.
These are their stories. These are their stories.
Previously on Convicted.
I didn't actually have a child safety seat.
He got followed by a rogue road rage driver. The shooting occurs. The driver drives off.
Okay, should we go to Texaco? Yeah.
It was like it wasn't even happening. I just remember my aunt and uncle guiding me through the church, and I went to see Asia. And
this call is from
Richard Nicolas,
an inmate at a Maryland correctional facility.
Richard Nicolas was arrested and charged with murdering his 2-year-old daughter in 1996. Then, in 1997, he was tried in a widely publicized and emotional trial in a courthouse in Baltimore, Maryland. I'm Brooke, and this is episode 4 of Convicted. I've never been to court or even been part of a court proceeding, though I did give a deposition once. It was in a huge, echoey conference room at an attorney's office. And I remember being overwhelmed, fascinated, and terrified all at the same time. I was also unbelievably grateful that there was a competent attorney sitting next to me that was on my side. Richard Nicolas had 3 attorneys sitting next to him, and in their time, they were considered competent, and maybe even the best. There were also 2 attorneys sitting across a small aisle from him that were also competent and very eager to see the defendant punished. A trial begins with jury selection, and so will I, because really, it's as good as any place to start. Jury selection is where we meet the players in the courtroom, and also where the very basic elements of our right to a fair trial begin. Pay close attention, though, because perhaps it was that during this routine procedure that the lines of justice first started to blur. I need to make a side note before talking about jury selection, because before jury selection, before any part of a trial even begins, something very important has to happen. The judge has to schedule it.
The issue came up in the voir dire preparation. And that, is, again, is something very usual. The state would provide its voir dire, the defense provides its voir dire, and you meet with the court, and the court decides which questions they asked and those that it would not ask. And one of the most critical questions asked is, this case will take so many days. Is there anybody who cannot, because of some serious commitment, not be able to sit? I raised that issue because on the days that were allotted, we had already used some of that time. The comment about 5 days or a week was 5 days of trial time, at least. 5 days of trial time. That did not include selection of a jury, did not include opening statements, did not include closing argument, and did not include instructions. And I raised the issue because I was concerned that she was going to tell this jury that they needed 1 week and the case was going to take longer than a week. And she started on me and said something you all said it was only going to take 1 week, and then we got into our discussion about that. But that's how the issue arose, and that's how it came up.
That was Howard Cardin, one of Richard's attorneys. We'll talk more about him a little later. It's my understanding from the transcripts in this case that each side told the judge that they would need a week for this particular case. So the judge, Judge Hubbard, scheduled a week for the trial, and then a vacation for herself afterwards. I mean, it sounds reasonable. She's a hardworking lady. She deserves a vacation. The issue is that each side was suggesting that they needed at least 5 days to present their evidence. In this case, that meant 2 weeks in total. And this confusion led to a scheduling oversight. I asked Arthur Cheslock, another attorney defending Richard Nicolas at the trial, what he thought about the scheduling matter.
She's a very nice person, but I certainly didn't like her off the record statement that she would not stay and didn't want to work further because she had a family commitment to be out of town. And I had written her a letter before that, although it was not required by a long shot, but it simply is a courtesy that we may need more time. And it was though I had never written a letter. You have to give the other side the time, and nobody can predict what is coming up. And so I didn't like her decisions with respect to that.
I have no evidence that this caused bias on the part of anyone. But I do know from the transcripts that the judge in this case mentioned on more than one occasion during this trial that lasted 13 business days that she would not miss, or later was not pleased with, missing her vacation.
I think, if anything, it may have reduced some of the state's presentation. The problem is Judge Hubbard was not a particularly rapid judge. If we had a different judge, I think the case would have moved much more quickly, and the estimate was fair. You always have that. You have some judges who are fast and some judges who are much slower.
Okay, let's talk about jury selection and how a juror that may or may not have had a self-identified preconceived judgment landed on the jury. We need to take a minute to talk about our sponsor. I have the SeatGeek app on my phone, and I've just discovered that it is by far the easiest way I've found to shop for tickets. I can be anywhere, and with just a few taps, I can instantly find my seats. I was inspired to get the app from my friend Scott, who told me about his genius use of the SeatGeek app. He and his sons are on a quest to visit every major league stadium, and SeatGeek has been with them for every one of their 7 stops. The next stop is Northern California, where they were able to use the SeatGeek app to get the tickets that they wanted for the A's and the Giants back-to-back. Plus, with SeatGeek, they were able to pick the seats exactly in the stadium where they wanted to watch from. He travels a lot for work, so the fact that he can pretty much use SeatGeek anywhere to save time and money is a major plus. And because every purchase is fully guaranteed, so you, Scott, and I can shop for tickets on SeatGeek with confidence. Make SeatGeek your go-to app for finding the best deals on every type of ticket, from sports and concerts to comedy and theater. And who knows, maybe you'll see me there. Best of all, my listeners get $20 off their first SeatGeek purchase. Just download the SeatGeek app and enter promo code CONVICTED today. That's promo code CONVICTED for $20 off your first SeatGeek purchase.
Jury selection is an incredibly complicated and subjective process that is never going to be the same and is never going to be dictated by the same considerations or criteria from one case to the next.
And because Richard was to be tried by a jury, it goes without saying, except that I'm saying it, that the first step in the process was to select the jury. The jury selection process is fascinating to me, so much that I could probably spend an entire episode sharing every intricate part. But we just don't have the time for that. So here are the basics. To be chosen for a jury, you likely are registered to vote or have an identification card issued by the state. You receive a letter in the mail that congratulates you on being chosen as a potential juror. And somewhere in that same envelope is a demographic survey, and you have to fill that out and return it to the court. At this point, you've become a number. I've been told that if you're a person who doesn't want to serve on a jury, that you hope for a high number, because the night before you're scheduled to report, you call an automated number, and it tells you if you'll actually need to be there or not. So, if 1 through 200 are mentioned, and you're 201, then you have successfully evaded your civic duty. If you are in fact required to attend, you report to the jury waiting room at the courthouse. The way the jury waiting room was described to me by a person, formerly called a jury duty, was less than pleasant. The accommodations include folding chairs, linoleum floors, and walls that could use some updating. The person described it as institutional-like, and went as far as to say it was barren and awful. Sometimes you wait a really long time in that room before someone comes in and calls your number. When your number is called, you then go to the assigned courtroom. According to the transcripts in the case of Richard Nicolas, so many people were called as potential jurors that the courtroom had to be cleared of everyone in the audience to ensure all the potential jurors would fit.
Because it was a first-degree murder case, there were 20 and 10 strikes, that is preemptory, that defense could challenge for any reason 20, state 10, and of course you would have your challenges for cause. Because of the nature of the case, there was a concern that there would be a lot of challenges for cause. So the panel was rather large. The courtroom was not a large courtroom.
As a non-attorney, my understanding is that the demographic surveys that you mailed in are given to attorneys on both sides so they can determine how to stack the deck, or I guess stack the jury, in a way that they felt was most beneficial to them. So they start with a pool of a lot of jurors,
to ultimately end up with 12 jurors and 2 alternates. There is an extensive list of questions, sort of screening questions that the judge asks. Those are called voir dire, V-O-I-R-D-I-R-E. And those questions are asked of the jurors as a group, and then they relate to subjects that may lead a juror to express through his answer that he or she can't be fair and impartial based on any number of reasons.
When a person answers a question in a way that makes it clear that they would not be able to perform their duty without impartiality for whatever reason,
there can be a challenge to that juror right then and there called a challenge for cause. And that's one that the judge has to agree to strike that juror right then and there.
Or if cause is not found or justified by the court, the attorneys have the options to use the other kind of challenge.
The parties can exercise what's called peremptory challenges, which are challenges that can be based on pretty much anything. There are some prohibited discriminatory bases for challenges that are not going to be tolerated by the court, but this is the situation, this is the time in the trial where a challenge can be made just because you don't like the juror's hairdo or because you think that the juror is scowling at your client. and or for any number of more sophisticated reasons than that. And at that point, each side gets a certain amount of peremptory challenges, and then when they run out, they run out. So they have to constantly be thinking, who is worse than the next one, and you have to kind of budget your peremptory challenges.
When the jury pool has dried up significantly, the opposing counsel have 20 opportunities each to challenge or strike the remaining jurors. But how does an attorney decide how to budget their challenges?
Most and generally because some of the answers that are given concern me as a person trying to judge whether the person will be fair in the sense of accepting our defense. And it's hard to say that. Frequently, it's a matter of how they answer the question. Sometimes age is a factor. Sometimes their occupation is a factor. Some attorneys are concerned about prospective jurors who might be in education. Certainly anyone who is related to police investigations, police officers, law enforcement, state's attorney's office will be scrutinized. So those are some of the factors. Some of the others are just the defendant may say to us, I don't like the way he looks, I want him off of there. And we would respect that also.
Sometimes, in a high-profile case like this one, an answer to a voir dire question will prompt the judge to ask the juror to come to the bench so they can be further questioned and determine if they're an appropriate choice for jury duty. This happened several times during Mr. Nicholas's trial, as according to the transcript. But I'm only going to tell you about one.
Juror number 72.
That is potential juror number 72. When during the jury selection process, the question was asked if anyone would have difficulty being fair because of the age of the victim, potential juror number 72 indicated that yes, he would have difficulty being fair. So he was asked to step up to the bench with the attorneys and the judge. Judge Hubbard asks him if he's already made up his mind that the defendant has killed his child. 72 responds that he's trying not to, but he's swayed in that direction.
The court, on its own, as Christina pointed out, rehabilitated the juror. Right. And we frequently see a juror who says, I cannot be fair because of a particular reason. And then the judge will ask questions in such a way as for the juror to say, well, that's not exactly what I meant. I mean that if somebody is 2 years old, then I would be very upset about the case, and therefore I was concerned that I might be prejudiced or biased. But as to Nicholas himself, no, I wouldn't be. And that's sort of what Judge Hubbard did.
Then, after 2 more times of 72 stating that he probably would think the defendant is guilty, the judge takes a different approach and asked 72 that if he were on trial, would he want someone to prejudge him without the facts? An entire page of conversation later, with the judge ending with, and that means you can be fair, and 72 replying, I guess I can be fair.
The challenge for cause was overruled. So it then left us with the right, certainly, to use a preemptory strike. I recall that we, when I say we, Cheslock, Gutierrez, Nicholas, and myself huddled on each of the strikes. I don't recall specifically what we did as far as 72 is concerned.
Potential juror number 72 was not only not struck as a potential juror, but also became a member of the final jury. He was actually seated as juror number 1, the foreman. So after a long day of waiting, asking and answering questions, and a parade of potential witnesses, on June 6, 1997, 12 jurors and 2 alternates were chosen to decide the fate of Richard Nicolas. We need to take a minute to talk about our sponsor.
Hey, Blake, have you heard of Movement Watches? It's the company that was started by 2 broke college kids that wanted to wear stylish watches but couldn't afford them.
You mean that company that we can totally relate to because of our similar story? 2 broke advocates who want to share a message with the world, started a podcast, yada, yada, yada. Yeah, not only have I heard of them, but I'm wearing my Movement watch right now.
Really? You have a Movement watch? What's it like?
Oh yeah, man. Let me tell you about the quality. It's built like a classic watch. This thing's not going to fall apart. It's very modern, Brooke. And, you know, I can go out. If I'm going dancing, I can wear my Movement watch. If I'm going to a dinner party for work, I can wear my Movement watch. If I'm going to an overpriced tapas dinner, I can wear my Movement watch. It's really great. They start just at $95 too.
Seriously? I was at the department store the other day and watches were like $400 to $500 for what you're describing.
Oh no. Movement, they figured out by selling online, they were able to cut out the middleman and the retail markup, providing the best possible price. That's probably why they've sold over 1 million watches in over 160 countries.
That is a lot of watches.
Yes, it is.
If you want to get 15% off today with free shipping and free returns by going to mvmt.com/convicted. This watch has a really clean design. Seriously, Blake has been telling me about it ever since he put it on. Now is the time to step up your watch game. Go to mvmt.com/convicted. Join the movement.
A courtroom almost reminds me of a boxing match. You have the spectators, the fighters in the form of attorneys, the ref in the form of a judge, and the scorekeepers are the jury. Each time an attorney makes a point, however subjective that might be, the jury adds a tally mark to their invisible scoreboard, and then, in the end, they determine the winner. Actually, it seems to me that the defendant really has very little to do with the process. They seem like the person who's made a gamble on the outcome of the fight. For the prosecution, in the state's corner, was Sharon May, Deputy State's Attorney, and Roberta Siskind, Assistant State's Attorney.
Sharon was a very competent prosecutor, you could tell that. I think that she did not necessarily disclose everything she had. I don't think she was required to. I don't in any way criticize her prosecution. There are some prosecutors that say, here's everything we have, now go and defend it. And there are others that say, here's what we have. Here's the medical report. And you take it from there and you investigate where it is.
I sent an email to Ms. May asking if she'd be willing to speak with me. It basically said I was doing a podcast about the case of Richard Nicolas, and I asked her if she remembered. A week later, I followed up with another email, just letting her know it was okay if she didn't want to talk with me, but to please let me know so I could stop following up. She did respond, and her letter read like this, quote, I do indeed remember this case. I can still visualize the autopsy photo of Asia showing the gunpowder stippling on her eyelids. As I said in my closing argument, I hope she was asleep and never saw her father pointing the gun at her and pulling the trigger. I have no problem speaking with you. However, if the purpose of your audio podcast is to work towards getting Nicolas a new trial, count me out. Serial did a podcast on the murder of a college student, and her killer boyfriend, Syed, got a new trial. I wrote back and let her know that I did not know what the outcome of the podcast would be. But I told her that the remaining 2 attorneys for the defense had agreed to speak with me, and that to make things less biased, it would be beneficial to the listener to hear her information firsthand as someone who was a prosecutor, not from my interpretation of the transcripts. That was mid-April, and as of yet, I haven't heard back.
Sharon May, both of them did some incredibly underhanded stuff that I'm like still finding out about how bad they tainted the trial process. But it had seemed like that she was on a vendetta type of thing to make me look as bad as she possibly could. It's Roberta Siskin wasn't as theatrical, but she played Sharon Mays second to a T. It's with their whole process.
I wasn't able to contact Roberta Siskind. I'm not able to say with any certainty if she would have responded or not. I asked Mr. Cheslock what he could say about the defense attorneys.
I can't say anything very nice about them. We were requesting I was requesting certain things, and they were not forthcoming. When we requested, for example, certain tapes and things, and I wanted them in a certain way, they had to be requested several times, and when they came, they were not as, for whatever reason, I don't recall what it was, but we couldn't use them, and they wanted to charge us, and they knew damn well that, quite frankly, we couldn't afford it.
We need to take a minute to talk about our sponsor.
MHC Choice is a streaming service that features European mysteries, dramas, and comedies. You can watch them right on your computer, TV, or favorite device. There's new content added each week, so you'll always have something new to watch, all with English subtitles. They have award-winning true crime series like Almost Perfect Crimes and The Godless, plus acclaimed crime drama like Spiral, In the Face of Crime, and Raid. They also have TV adaptations from some of the world's best crime fiction writers, including Agatha Christie, Donna Leone, and Camilla Lackberg. Most recently, I've been watching Crime Stories. It's based on a best-selling book, and in this 6-part series, you hear unusual cases that were inspired by actual crimes. Each standalone episode delves into the crime from the viewpoint of the perpetrators, victims, and witnesses, and they're all connected by the same defense attorney who seeks justice for his clients. You'll get the Crime Story series plus the entire MHC Choice library, which includes over 2,500 hours of binge-worthy TV for only $7.99 a month. So you can try MHC Choice free for 30 days. And after that, you'll save 50% off your first month. Visit mhzchoice.com/convicted and use the code CONVICTED at checkout. That's mhzchoice.com/convicted. And thank you, MHZ, for sponsoring this podcast. Because remember, when you support our sponsors, you're supporting us.
In the corner for the defense, Richard's corner, was Christina Gutierrez, Howard Cardin, and Arthur Cheslock, all very well known and high-performing individuals at the time. A dream team, really.
I had Howard Cardin, which is one of Baltimore City's best criminal defense attorneys. Arthur Cheslock. Arthur's a outstanding guy. Arthur's been practicing law longer than I've been on this earth, and I am 51. So Arthur has a lot of experience. Christina Gutierrez, we had hired her because at the time also one of Baltimore City's best criminal, defense people. I remember her being, good at what she did.
Arthur Cheslock is currently 78 years old. And after only talking to him for an hour or so, I believed him to be one of the most compassionate people I have ever met. He was soft-spoken, but sharp, and he was able to answer my questions frequently before I even needed to ask them. If I had to label his part in the defense, I would label him as the charmer. I imagine he was the member on the team that would have most been likely to connect with the jury.
Art is a great guy and was a good lawyer, was a good prosecutor. But he did not have the aggressiveness that I think Christina and I had.
Rachel and I were together when I interviewed Howard Cardin. It was funny to me because Rachel and Richard separately both described him as the tough guy Baltimore City attorney, when I was later struggling for the words. I think he's a good guy with very good intentions.
My name is Howard Cardin. I am an attorney. By background information, I was sworn in to the bar in 1965. I went into the state's attorney's office in 1966 and continued as an assistant state's attorney until July of 1970, at which time I became the state's attorney of Baltimore City. Lost the election since it's a political office, and went into private practice in January of 1971, doing predominantly criminal work. Been doing it ever since.
Christina Gutierrez. I mean, let's address the elephant in the earbuds here. She obviously had some issues that affected her performance in another trial, presented in a different podcast, in a studio far away from my closet. But I wanted to know about the Christina Gutierrez of 1997, the one that was fighting in Richard's corner. So I asked some people that knew her.
I thought that she was as good as could be expected.
And asked,
So Christina Gutierrez, very excellent attorney in her day. She was really top-notch criminal defense attorney, known for being a real bulldog in the courtroom, very tenacious, very diligent, take no prisoners sort of approach to trying a case. And I could see why Richard hired her based on her reputation for all of that.
And asked.
At that time, she was known as an extremely aggressive defense attorney who was really considered to be very, very good at her job. And her job was to cross-examine and try to impeach, destroy a witness. I thought she handled herself well. Yes, I have no criticism of Christina Gutierrez.
And after all that asking, I didn't find what I, and I suspect that many of you, were expecting. Even looking through my lens of what might be described as unintentional confirmation bias, I didn't find any fault with her performance on that first day of proceedings. So, nothing to see here on this matter. Feel free to try back later. In the front of the courtroom, at her large desk bearing the gavel, was Judge Mabel Hubbard, who, in fact, was the first African-American attorney to be appointed to the bench in Maryland. That was information that Richard shared with me. Judge Hubbard started the trial, with some preliminary remarks. She instructed the jury on what they must do to stay within the bounds of the law and to give this defendant, Richard Nicolas, a fair trial. Her directive seemed fairly straightforward for the most part, but then I came across something that made my social work senses tingle. After pointing to the witness chair and indicating to the jury that the witnesses would be asked questions from that spot, Judge Hubbard stated, quote, "Listen to those questions, and listen carefully to the witness. And I want you to not only listen to the words they say, and treat every word as if it were a crisis. I want you to listen to the tone of voice. I want you to listen to the inflection. And then I want you to watch that witness. You must watch the facial expressions. You must watch the gestures. You must watch the body language. In other words, you must see every nuance about every witness to help you decide. Number 1, whether that witness even knows what he's talking about. And number 2, whether that witness speaks the truth. Unquote. Okay, so listen to this part again. You must listen to the tone and inflection of their voice. You must watch their facial expressions, body language, and gestures. Those words, the words of the court, could be interpreted in many ways. You could propose that she was just reiterating how a human brain interprets language and nonverbal cues from one person to another to determine credibility. Or could she have possibly just told the jury to be discriminatory against a man with a speech disorder, a man who sometimes uses unusual nonverbal techniques to help his words come out? The same man whose own attorney, later on that same day, stated that his intentions could be misinterpreted by the exact mannerisms the jurors were instructed to use when determining his honesty. Maybe I'm the only one who thinks that.
Lovely lady.
Yeah.
But she was not in control of a case in the sense of having it move rapidly.
But would you consider her fair? I mean,
yes.
She was.
Yes.
Okay. With all of the players in their positions, it was time for the opening statements to begin. An act that Judge Hubbard explained as a preview of the upcoming attractions. In any and all cases, the state goes first, because the burden of proof lies with them. Sharon May began her opening statement with powerful words. Words that I've asked a friend of mine to help me share to break up my voice a bit. Quote,
"She captured the hearts of her mother, her grandfather, her godfather, her cousins, and even the staff at her church day camp. Asia, 2 years old, captured the hearts of all, except one."
She went on to outline the points of her case, or the preview, as previously mentioned by the judge. She talks about the fact that Asia was conceived during a one-night stand, and implies that her father suggested an abortion. She goes on to say that he was absent for much of her life and beyond, quote,
"crowing about his biological accomplishments,"
that he also didn't want to take financial responsibility. She pointed out that he had asked for a paternity test, and when it came back positive, his financial support was still at best inconsistent. She talked about his gun collecting hobby, mentioning that he could afford expensive guns, but not find the funds to support his daughter. She mentioned the many milestones, holidays, and birthdays that he had not bothered to be present for. And she mentions that in March of '96, Richard took out a $15,000 Gerber life insurance policy on Asia, and she suggests that he was the sole beneficiary. She talks about how Asia's mother reluctantly let her go to the movies with a man who insisted she give her daughter, quote,
"her last kiss goodbye."
She recounts the road rage incident and talks about scientific testing, like gunshot residue. And then she closes with,
"everything pointed to the fact that he was the one who held the gun and killed his own child."
Of the three impressive attorneys representing the defendant, Christina Gutierrez delivered the opening statement. I don't have audio of her voice, no matter how much I had hoped to, and no one I know could emulate her well-known way of speaking. So it's just you and me discussing the delivery of her opening statement. I didn't notice any errors staring me in the face when I read through it. Really? The only thing I did notice, setting it apart from the opening of the state, is that there were significantly more pages in Miss Gutierrez's remarks. She introduced Mr. Nicolas and reminded the jurors that they had agreed to be impartial and fair during the trial. Obviously, I wasn't there, but I half hoped that she had looked at juror number 1, former juror number 72, while making the statement. She makes it plain that this case is about Asia. And then, in the same sentence, she tells the jury that it will not be easy for them to see, quote, gruesome pictures of a bullet hole through the face of a 2-year-old. She uses her wordy and passionate manner to outline the reasons the jury should not convict Mr. Nicolas. He came from a good, loving family, and he was a loving father to Asia. He had a speech disorder, and because of it, he talks slowly and deliberately to be understood, and that if he becomes upset, it's harder for him to communicate. She implies that if someone did not know that he had a speech disorder, they might mistake his calm manner of speaking for a lack of emotion. She talks about his education, his job skills, and she talks about the one-night union between Richard and Asia's mother. She normalizes his request for a paternity test before he began child support payments, and also highlights that the Gerber Grow Up plan was an investment in his daughter's future. She talks vividly and at length about the night Asia was murdered and the lack of evidence that the state had against Mr. Nicolas. Then, when her time finally comes to an end, she reminds the jury, quote, "You are never allowed to lift the burden from Miss May and Miss Siskin's shoulders, because they represent the due process of the law."
You have 60 seconds remaining.
I was reading the transcript about how you couldn't go into the trial because you were going to be a witness. How did it feel to not be able to go in?
It hurt me because I wanted to be there for my brother. I just wanted him to be able to lay eyes on somebody who loved him. And I think the whole week was torment for all of us because I just wanted him to know that, Mom and Dad weren't here, I was here. And I'm never going to turn my back. And it hurt me that I couldn't see him while he was going through what he was going through. Because I know that he had no friendly faces in there. So it was constant torment.
The prosecution's case on the next Convicted. Thanks for listening. You can see pictures and other documents at convictedpod.com. Convicted is hosted and produced by me, with music and scoring by Blake Maples. You can see and hear his work at blakemaples.com. If you like what you hear, please give us a rating and a review on your podcast app. And be sure to subscribe so you're the first to hear the next episode of Convicted. Thanks again for listening. I've been reading through, I'm on page 150, which sounds like a lot, but it's not really that far, of your original trial transcript.
That thing's like 3,000 pages long. You know that, right?
Yeah, it's really long. I'm getting my reading, and since I finished grad school, I never wanted to read again, and now that I've started this, I can't put it down.